application of Evans and Her Majesty's Attorney General.
The statutory background to this appeal is that the Freedom of Information Act 2000, FOIA, enables members of the public to see documents held by a public authority subject to certain exemptions. And the Environmental Information Regulations 2004, the regulations, which were made pursuant to a 2003 EU Environmental Directive, enables members of the public to see documents held by a public authority if they contain what's called environmental information, again subject to certain exemptions. If in either case the public authority refuses an individual's request to see a document, the individual can complain to the Information Commissioner, who's an independent official, who can serve an enforcement notice requiring disclosure of the document if he thinks it should be disclosed. The individual or the public authority can appeal against the Commissioner's decision to a tribunal, which is a judicial body, and which can also issue an enforcement notice if it thinks that the Commissioner should have done so. The tribunal's decision can be appealed by either party to a higher court. If an enforcement notice is served, Section 53 of FOIA and Regulation 18.6 of the regulations entitle a member of the government, in this case the Attorney General, to issue a certificate stating that he has, on reasonable grounds, to use the words of the section, formed the opinion that the public authority had been entitled to refuse disclosure and setting out his reasons, whereupon any enforcement notice ceases to have effect. As to the facts of this case, in April 2005, Rob Evans, a Guardian newspaper journalist, requested disclosure of letters passing between various government departments and His Royal Highness the Prince of Wales. The departments refused to disclose the letters because they considered them to be exempt under FOIA and under the regulations. Mr. Evans complained to the Commissioner, but he upheld the department's refusal. Mr. Evans then appealed to the tribunal, which after holding a 6-day hearing, concluded in a closely reasoned decision that many of the letters, which they called advocacy correspondence, should be disclosed. The government departments did not appeal against that decision. However, the Attorney General issued a certificate under Section 53 of FOIA and Regulation 18.6 of the regulations. If this certificate is valid, its effect would be to override the decision of the tribunal and effectively set aside the enforcement notice. Mr. Evans then issued proceedings to quash the certificate. The Divisional Court dismissed his claim. However, the Court of Appeal allowed his appeal. The Attorney General now appeals to the Supreme Court. The issue is whether the certificate is valid, and the Supreme Court has not needed to see and has not seen any of the letters in question in order to determine the issue. That issue raises the following questions. 1, was the Attorney General entitled to issue the certificate on the grounds that he did? And if he was entitled, 2, first, do the provisions of the EU Directive permit the issue of such a certificate in relation to the environmental information? And secondly, if not, to what extent, if any, is the certificate valid? In summary, the Supreme Court, by a majority of 5-2, considers that the Attorney General was not entitled to issue the certificate, which was therefore invalid. Further, by a majority of 6-1, the Supreme Court holds that Regulation 18.6 was incompatible with the EU Directive, so the certificate would in any event have been invalid in relation to environmental information. Accordingly, we dismiss the Attorney General's appeal and the decision of the tribunal that the advocacy correspondence should be disclosed under the Freedom of Information Act, and in the case of the environmental information, under the Environmental Information Regulations, stands. So far as the judgments are concerned, in relation to FOIA, in a judgment with which Lord Kerr and Lord Reid agree, I conclude that Section 53 of FOIA does not permit the Attorney General to override a decision of a judicial tribunal by issuing a certificate merely because, on the same facts and arguments as were before the tribunal, he took a different view from the tribunal. To hold otherwise would involve recognizing an unprecedented statutory undermining of two constitutional principles fundamental to the rule of law, namely that the decision of a court is binding between the parties and cannot be set aside, and that decisions and actions of the executive are reviewable by the courts and not vice versa. Clear words must be used if the statute is to have that effect, and Section 53 is a long way from being clear enough. In his judgment, Lord Mance, with whom Lady Hale agrees, considers that it would have been open to the Attorney General to issue a certificate under Section 53 of FOIA because he disagreed with the decision of the tribunal. But disagreement with findings of fact or rulings of law, particularly made in such a fully reasoned decision, would require the clearest possible justification, while disagreement as to the weight to be attributed to competing interests would require the Attorney General to give properly explained and solid reasons. The Attorney General undertook his own redetermination of the relevant factual background, which he was not entitled to do, and the reasons do not engage with the closely reasoned analysis of the tribunal. The Attorney General proceeded on the basis of findings which differed radically from those made by the tribunal without real or adequate explanation. Lord Wilson and Lord Hughes each give a judgment dissenting on this issue. They each consider that the Attorney General was entitled to issue the certificate on the ground that he did. Accordingly, they dissent. As to the judgments on the regulations and the EU Directive, Lord Mance and I, with whom Lady Hale, Lord Kerr, Lord Reid and Lord Hughes agree, point out that the EU Directive requires a refusal of disclosure to, and I quote, be considered or reviewed administratively, and that such reconsideration or review should be able to be challenged by, and I quote again, a review procedure before a court of law or similar body whose decision may become final and binding on the public authority holding the information. In the light of these provisions, we consider that it would be impermissible for the executive to have another attempt at preventing disclosure after a tribunal had held that they should be disclosed, and therefore Regulation 18.6 of the regulations is incompatible with the EU Directive. This conclusion only applies, or would only apply, to the environmental information. Lord Wilson dissents on this issue as well. The court is now adjourned.